matters 7 and 8. Lordship, learned senior counsel, Mr. K.K. Mahanta is not well today. Lordship, the matter may kindly be adjourned.
Item number 7 and 8.
7
Yes,
and
ma'am.
8.
So I am for.
Who is
the
not,
matter,
who's unwell? who is
Mr.
not well?
K.K. Mahanta.
KK Mahanta. What to do? Okay, right. Adjournment prayer has been made on behalf of Mr. KK Mahanta. Senior counsel? or
Yes,
Yes, yes.
Learned senior counsel. For the appellant, on the ground that he is unwell. Full stop, the same is not objected to by Ms. B. Buyan, additional PP. Accordingly, release this matter after the vacation.
My lord.
Much obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number
Number
13.
13.
Yes, Lordship.
They had given adjournment sleep yesterday.
Okay, right. Adjournment prayer has been made on behalf of Mr.
K. Bhattacharjee.
K. Bhattacharjee, learned counsel for the respondent number 2, which is not objected to by Ms. B. Buyan, additional PP. This is the matter after the vacation.
My pleasure.
Happily. My lord, service report in respect of respondent number 2 is waited here.
Is
Waited. Waited.
Paper book is ready.
paper book is ready.
Yes. I've got it.
So now the thing is that the notice was issued.
Hmm.
But what to do? So we have, this is a POXO case.
Not a POXO case, I think, 366 or what?
No, POXO case.
POXO.
Delay in filing the appeal. And keeping in view the submission made by the additional PP, we find sufficient cause for the delay has been made out. Because of the delay is accordingly condoned. Registry to register the appeal and list the same after a week. I is accordingly disposed of.
Not.
Highly obliged, Lordship. Yes.
Difficult case. No way out.
Let me try my. Let me.
No way out.
No way out. Lord.
No way out, this one.
According to me. it
You're
was
the elder
circumstantial
brother.
evidence, my lord.
You're the elder brother, you killed your
I'm
younger
the
brother.
brother.
You killed.
But only a
Only
quarrel.
thing is that whether, yeah,
Quarrel.
there's a quarrel.
There was a quarrel.
So whether, whether you can lessen your sentence,
This is what.
304.
There
That's all.
extrajudicial confession also. He himself said there was a quarrel.
So in the heat of passion,
Yeah, heat of passion. He went to his father's.
grave and sudden provocation, is it?
There's grave and sudden provocation, no material to show where he got this.
I don't know. So and all the witnesses are the relatives only,
Natural.
natural relatives. It is not, it's not disputed, I think, by anyone that the elder brother has killed the younger brother
Even father said,
due to a quarrel. All the witnesses are mother, father, all that thing, all those persons.
sister.
Yes, so I mean, there's no denying the fact that you are the perpetrator of the crime. Now, whether you had an intention to kill earlier or was it a sudden provocation, that is the only thing that has to be acknowledged.
And one more fact, he was not taken to the hospital on the night itself because of paucity of money, they say. So had he been taken, perhaps he would have survived.
Maybe, you know,
Morning, he was taken to the
that
hospital.
is speculation, no?
But then, not instantaneous death, rather.
Could be.
To bring it down, I mean, or to bring it down.
How much can we bring it down? Can we bring it?
For that, let me place my case.
Yes, yes.
I'll raise some points.
Yes.
And thereafter, your lordship will consider
yes.
whether it should be
Sure, sure.
reduced
Okay.
or should I be acquitted, madam?
Acquit.
Acquittal.
Because this is
There
a
is a
case
lot
of circumstantial evidence, madam.
Mm.
There is not a single eyewitness.
Not an eye, no eyewitness.
The
but
police
yes.
has not uh, proved the murder weapon, madam. They have not sent the murder weapon for forensic, my lord, to say that the fingerprints were there on, my fingerprints were there, or blood was there. Nothing.
Okay,
Acquittal.
you start, you
The
start.
circumstantial
Lordship,
evidence is not complete, my lord, according to me. my lord. PW1 is the informant, my lord. She is the wife of the victim, my lord. PW1, page 12, my lord.
Page 12, yes. Let us go to the FIR.
FIR,
Yes,
my lord. FIR, page 5, my lord.
page 5 FIR.
FIR.
Who is the informant?
PW1, the wife of the victim.
Wife of victim. Yes,
Now, the FIR says it's dated 2/7/2016, madam.
27,
2016. The offense occurred on
Yes.
36/2016
yes,
around 8 p.m. madam.
yes,
I, Aloka Musahari, wife of Nelson Musahari, the victim, resident of so-and-so place, have the honor to state that 8 p.m. on 36/2016, my husband, Sid Nelson Musahari, went to the nearby house of his father. Later on an argument took place between him and his younger brother, the appellant, Alongbar Musahari, over certain matter. Later, Alongbar Musahari assaulted him, my husband, with an axe lying nearby, whereupon he fell unconscious. Though he was being taken to Kochugama Public Hospital the following day, not the same day, madam. On the following day, that is 1/7/2016 Friday, he succumbed to the injury on the way. I therefore earnestly request,
so that means he lived for some time.
he was alive.
He is alive.
He was alive for at least 18 hours. I
Huh?
can show. For at least 18 hours, he was alive. Now, she is an illiterate person, the informant, my lord. The LTI is there, left thumb impression. She has not signed it. Somebody else is scribed.
Okay, okay, we get it.
PW1, my lord. Our evidence,
Page,
page 12.
page 10.
12.
12.
In our evidence, she says in chief, the incident took place about 4 months ago. I was in my maternal house in the evening. Having heard a hue and cry in my husband's house, I went there and saw my husband lying smeared with blood. When asked, he replied that accused Alongbar has assaulted and caused him injury. I pause for a moment, madam. Reading this last line, it seems that her husband stated that his younger brother, the appellate, has caused the injury.
Correct.
Madam. My husband succumbed to the injuries while he was being carried to the hospital. I lost the Azahar with the PS on the following day. Although she says that I had lost the FIR, but what are the contents of the FIR, she does not prove. Madam, in cross, she says, because she was in her maternal house, she came down after hearing the hue and cry. I saw no other person near my husband. Her husband was lying smeared with blood alone. On the following day of the incident, my husband was kept in the house for a night. For one night, he was kept in the house. No medical treatment was given. At about 11 a.m., the incident occurred 8 p.m. earlier night, 11 a.m. The following day, my husband was taken to the hospital for treatment. I lost the Azahar on the following day of the death of my husband. On my arrival, I found the accused at the place of occurrence. The first paragraph of the cross, first line, and this line are contradictory, my lord. She says, I saw no other person near my husband. Now she says, on my arrival, I found the accused at the place of occurrence. When asked, the accused replied that the quarrel had taken place between him and the husband, and that he has assaulted and caused injury to my husband. My husband was not in a condition to speak. Now her examination in chief, she says that her husband has told her.
Not in a condition to speak.
This is contradiction. And so far as my saying, the appellant saying that a quarrel had taken place and I had assaulted him and caused that injury. This is an extrajudicial confession if admitted. And it does not say that I had the intent or motive or that I had given him that blow with such intention that he would die. He simply says that a quarrel had taken place and I had caused an injury to him.
Yes, then,
PW2, my lord. He is our father, my lord, appellants and the victims. Nelson was my son. He is the victim. The incident took place about 6 months ago. At about 8 PM in the night, I was cutting firewood near the house. Having heard halla, I came to the house and found my son Nelson lying injured. Accused Alongbar was nearby. When asked, Alongbar replied that he had assaulted Nelson when Nelson attempted to assault him, and that he had assaulted Nelson with an axe. Again, an extrajudicial confession, my lord. Doesn't say that I had the intention or the motive. It simply says that because of a provocation from the victim. Let me read the last line again, my lord, at page 14. When asked, the appellant replied that he had assaulted Nelson when Nelson attempted to assault him. When the victim tried to assault me, in repercussion, I assaulted him. In cross, he says, madam, I did not see any weapon in the hand of Alongbar. The injured was not taken to the hospital on the day of occurrence for want of money. Nowadays, one phone call, 108. The ambulance comes, madam.
Mr. Council, these are
The
villagers, you please
Madam,
understand.
even the PS was not informed of the incident.
One phone call, I wonder how many ambulances come. Even in parties.
Any presumption matter has to be in favor of the accused matter. I did not see any acts
No, but
lying at the place of occurrence.
where is your ambulance part here? Where is the cause regarding ambulance? That one ambulance and they will come. That is your submission you are making here. That was not part of your cross. Then how can you put that as part of your cross? Yes, next.
He further says
So you
that
are, don't presume. You don't want this court to presume, you also don't presume.
because they are saying that because of want of money, they did not take. the
So what
victim
is
to
wrong?
hospital.
Naturally,
Money is not that much required, matter.
oh.
Government
not
hospitals are
required.
there.
I
Government
don't
hospitals are
know.
there.
I do not know. I thought money was paid all the time here and there. You see, sometimes they do need money. It's not that they might not need money all the time, but they do need money. To take him to the hospital, they need money.
The father further says, madam, in cross,
They,
that I did not see any X lying at the place of occurrence. At that time, Nelson was under the influence of liquor. Nelson was the victim, my lord. Victim was under the influence of liquor. One says that he caused a provocation. Again, he was under the
so
influence of
according to
liquor.
you,
Man.
your father is lying, your
I'm not saying he is
sister-in-law
lying.
is lying,
I'm not saying they are lying.
your sister also is lying.
I'm not saying they are lying.
That is basically what you're trying to say.
I am saying even if I admit whatever they are saying to be true,
But what will they gain by lying?
I'm not saying even for a moment
What
that
would
they are
be
lying,
the-
my lord.
What
I'm
would be the motive for them lying?
Even for a moment, if I say, my lord, they are not lying at all. But the circumstance does not complete, my lord. They have not
Okay,
seen me doing
carry on
the-
reading, carry on reading.
my lord. PW3, my lord. Next witness, my lord. She is my sister, my lord. Both the appellant and the victim's sister. She says, and chief, a quarrel took place between Alongbar and Nelson on the day of occurrence. I was cooking rice in the kitchen. Coming from the kitchen, I found Nelson lying on the ground. Alangbar told that he has assaulted Nelson with an axe. The axe was lying nearby. In cross, he says, Nelson Musar, the victim, had assaulted my husband, our brother-in-law. Nelson, it's the nature of the Nelson, the victim, that he had also beaten up our brother-in-law before the incident. Again, an extrajudicial confession doesn't say that I had the intention or so and so to kill him either.
Who is this Anima Mushahari?
Mother,
Mother.
Anima?
Acha, she's the mother.
mother of the deceased.
Anima is
Mother.
sister, my lord.
Huh?
Sister.
Sister?
Mother of the deceased.
Mother.
Oh,
Is it?
sister.
Victim's sister.
Sister. Sister of deceased.
This is and the appellate.
Sister of deceased. So if she's the sister,
Sister of the deceased.
then then the cross
Nelson was the-
examination, he says that Nelson Muazari had assaulted. Acha. So
Our brother-in-law.
Nelson had assaulted the father.
Father. No, brother-in-law.
Father.
Nelson Musari has
Nelson
assaulted my
had
husband.
assaulted my husband. Acha, acha, acha.
The witness is
Husband, correct.
our sister, my lord.
Yes.
She's
correct.
our sister.
Next.
Nelson, the victim, had assaulted our brother-in-law
Correct.
before the incident. PW4, my lord.
Yes.
Gandhi Brahma, most probably a neighbor or lives in the same village, my lord. He says that the incident took place about 6 months ago. In the night of the incident, he heard some shout and quarrel had taken place between Alangbar and Nelson. He must have heard by some third person. On my arrival, I found Nelson.
He's a neighbor.
Parents of Nelson said that they had no money to take Nelson to hospital. Nelson was taken to the hospital the following day. Nelson died on that day. In cross, it is not a fact that I know nothing about the incident. So whatever he says, he has heard from someone. PW5, my lord. He's the doctor. The doctor says in chief on 2/7, incident took place on 30, my lord. On 2/7 at 3:10 PM, I conducted the postmortem of Nelson Musahari and found a split lacerated injury seen left side of the forehead. My lord, the lacerated means there is a cut refers to a skin wound.
Huh?
It's a skin wound,
No,
Only on
no,
the
no,
skin.
no, no, no.
laceration,
It can mean many things.
not an abrasion.
Abrasion is in fact, it's very minor. Abrasion is more minor. Lacerated can mean a deep laceration, can mean a not very deep laceration. It can mean many things.
The meaning that I have taken out, madam. A laceration or a cut referred to a skin wound. Unlike an abrasion, none of the skin is missing. A cut is typically thought of as a wound caused by sharp object like a shred of glass.
First of all,
Fine.
this is, was there evidence taken in English? They are villagers. So
No,
did they understand the words that they were saying?
no, it's in,
Assamese. So let us see what was written in Assamese.
but the doctor might have been in English.
I don't know. Let us see. Huh?
Doctor in English.
Let us see the doctor's report. What does he say?
LCR.
Lacerated injury seen on this.
Huh?
Section. Left side of.
This is fracture of left front bone blood clot.
Only
There's a
one-
fracture.
Only one wound.
One is enough. One is enough. Don't you remember there was a famous cricketer who had boxed somebody and that person died. One box was enough. Then sometimes maybe one is not enough, but sometimes it is enough. Then
One hit, he died on the next day. Another option is Lordship can convert it to 326. an option.
I don't know,
Yes, he's for acquittal, so-
He's for acquittal.
Let us-
Now we'll have to see whether acquittal can come into play. He's-
Laceration is,
He's not going into any other arena, so we won't go into any other.
laceration is deep cut. It's a deep
Please
cut.
look at the dictionary.
Dictionary meaning
Just
is,
give me a dictionary.
in Google, it is a deep cut of or tear in skin and flesh.
No,
Skin or flesh.
dictionary, the fact book. Is it a dictionary? No.
Dictionary.
Just give me a dictionary, do you have Webster's or
No, dictionary.
Oxford or something, dictionary.
Lordship is,
Just give me this medical jurisprudence.
that will.
No, but just the camera. The camera. We cannot move it.
They got this book to attach the camera. Then the dictionary is there. Lordship.
Laceration, a deep cut
Hmm.
or tear,
And there is a split laceration.
especially in skin.
Hmm.
Action of making such a cut. Lacerate, tear or deeply cut.
But on the skin.
Deeply cut, Mr. Counsel, when you cut a skin, how thick is the skin?
And skin split laceration, I think in the instant case, it is split lacerations.
Split lacerated, split.
Split laceration. And split laceration, as I can find in the Google, it is caused by compression of the skin between the weapon and the bone.
I don't know from where you got this, but it's not very helpful. Yes,
The doctor further says,
and we'll just write for 2 minutes.
it's matter on page 21 matter.
Yes,
A fracture of left frontal bone, blood clot over the forehead under shell, blood clot between the subdural space inside.
you know where the subdural space is? Where?
Below
How
the
deep?
bone,
Ah,
below the bone of the skull.
you know, it's very dangerous. People die.
Right.
Subdural blood clot can happen due to many reasons, due to a stroke also. Do you know that? You don't know, I don't think.
Because of that injury, swelling of the upper eyelid, oozing of blood through left nose. And his opinion, he says, in my opinion, the cause of death was shock and hemorrhage. Hemorrhage is my lord, large flow of blood from a damaged blood vessel due to head injury, due to impact of a blunt object. It also will mark blunt object,
So axe,
axe, not the sharp side. Not the sharp side. Intention says, my lord, if I wanted to kill him, I would always use the
one
sharp
side, no, you
and I would have,
you have got, you don't have a clue. You see, I'll just tell you, though, you see, in the northeastern side, maybe not here, in the other, in the states, my state, sometimes they do kill animals. And they always use the blunt side. Always. Of an axe. And anyway, so That is the
Normally,
fact
if-
of life.
If
So-
my intention would be to kill somebody, I would use the sharp side, kill him instantly, or repeated blows till he dies.
Mr. Counsel,
No.
he's your brother.
Is my blood.
He's your brother.
But the provocation
Yeah,
was
with,
such. the provocation was
if you
such.
give him one blow and then you might feel sorry if he falls down straight away. Unless you're a monster, I think you will immediately you will feel remorse that you're why did I do that? But act is done. If you repeatedly hit your brother, I mean, that is, I don't know. Maybe your enemy you can hit repeatedly, but I don't know. Brother, if it can happen. Anyway, that is what you think is the normal behavior. Everything.
The next witness is PW6 Malot. He is
Yes.
the VDP secretary of our village. I've been the secretary of the VDP of the village of North so and so since that time. One day, about 6 months back, I was informed that a quarrel had taken place between Nelson and his elder brother. I went to the house of Nelson on the following day. Nelson was taken to Kochugaon Hospital for treatment, and therefrom he was referred to Kokrajhar Civil Hospital. But he expired on the way to Kokrajhar. So the Kochugaon Hospital, he was alive till Kochugaon Hospital. Therefore, after he was referred to Kokrajhar, in between he died, madam. I don't know why the fight between the Nelson and his elder brother took place. No cross, my lord, dear.
So according to you,
Madam.
since there was no eyewitness, this evidence given by the father, the sister, the
Extrajudicial
sister-in-law, they cannot be accepted they cannot be admissible in evidence.
even if accepted to be true, my lord. Even if accepted to be true, they say that I have told them that because of the provocation, I hate him. I've never said that I had the intention to kill him.
Mr. Counsel, have you ever taken a plea before the trial court that there was some third party person
No,
in the house?
in fact, I have denied everything.
You,
The
so,
accusations I have denied.
so the evidence shows that only two of you were together.
My father was also there.
So your
He
father,
was
so,
cutting, he was cutting the.
oh,
wood.
so your father
Then
was also there. So according to you, it could only have been your father or you who had killed. So now you're blaming your father also. Or is it?
Could be.
Is it? No, where is it?
He had the.
Where is
accident,
your,
man.
where is your cross examination or suggestion in 313 explanation that no, it was not me, my father had killed him? Where is that?
It's not there.
Then how can you say that?
The
Please.
accusations I have denied. All the
Then,
accusations that
okay,
have been
you have
put on-
denied. No, so the question is is it your case that some third party was there besides your father? No. It is not your case in the explanation that your father had killed.
It's not my case.
It is neither your case that he killed himself
No.
or he hit himself with a knife. Then how did it happen? Miracle. Black
That part-
magic.
That part has to be proved by the prosecution. The prosecution has to stand on their own legs.
Last
Even
scene
if I-
together. Last
Even if I
scene.
say,
Mr. Counsel, there's a thing called last scene together theory.
here it is first scene, madam, after the injury. After the injury.
Okay, after the
everybody comes-
injury, yes, after the injury, but no explanation given by you as to why, what happened.
There is-
You have not even trying to explain
There
the
is-
reason.
But the fact remains, madam. The PW7 matter, the IO. He has seized the X. Maybe after 2 days. But he has not sent it for forensic. He did not show that X because it was in the position, it was exhibited, it could have been exhibited to the medical practitioner matter to say that this was the instrument with which the murder could have,
That
been-
was not exhibited,
it was seized,
Seized,
seen but not exhibited,
not exhibited,
not sent to FSL.
not
not sent to FA.
not sent.
So, okay, those two points are, he should have sent it to
Ah.
FSL. And that should have been exhibited. But that doesn't take away the fact that there is no other plausible explanation accept the evidence given by these persons. So your case is basically to the effect that you're innocent, correct? No other, you're not taking any other.
I am saying that I did not have the intention or the motive to kill him.
So you're innocent, basically you're innocent.
If I had caused that injury,
No, you
Which is
see,
a-
let
which
us
is
be
a
very
previous
clear,
hurt.
let us be very clear.
My-
Your case is that you are innocent.
my case
So
is
we
that-
will go only with respect to whether you are innocent or not, nothing else.
But if I fail, my lord, in that, second leg of argument would be, my lord, it was a grievous hurt.
How
It was
can,
a grievous hurt.
how do you reconcile your two arguments?
It couldn't
In
be-
one argument, you are saying that you are not the cause of the death of your brother. But now you are saying, even if I was the cause of the death of my brother, this should be considered. How can it be? How can you reconcile two opposing stands? You have got to take one stand.
I have to take one.
You cannot go left and right. You divide your body in half.
What I'm saying is, even in the worst scenario,
That's why at the very beginning,
I
we
cannot
gave you
see-
we gave you some hint
options.
as to how you should go about this. But you're not taking it. We'll have to decide as per what you decide. Yes, you can tell us what is the citation in your favor.
My lord, I'm relying on this decision, my lord.
You're in a micus.
Am I correct?
You see, I don't know. Prima facie, we feel that you are going to do injustice to your client.
Then
The
I'll
way
take my
the-
second leg of argument, my lord. Your lordship will
We
consider
told
it.
you from the very beginning. We told you from the very beginning. Because the way you are going about this case, your father has given testimony. Your sister has given testimony. Your sister-in-law has given testimony. Eh, There is the other witnesses, there is no evidence to the effect that there was any other person except you two. And there is no evidence that your father killed him or your sister killed him or your sister-in-law killed him. I mean, it's such a closed argument that you have that at the end of the day, you are basically may not be doing justice to him at all. I could understand your plea if you were I don't know, that's a different issue anyway. But you have got to think properly about the facts of the case, the evidence that is there. Where is the escape hatch for you? I don't understand. Where is the reason for us to disbelieve the evidence of the father, the evidence of the sister? Father has lost one of his sons. It is not that there is no evidence to the effect that he hates the appellant or he hates the deceased or he loves one over the other. No, nothing there. Then there's the sister also, same thing. No, 320. 326. Yes, so are you going to stick to your argument or are you going to
I'd like to change it, madam.
change it? Yes. Sure.
I'd like to place, my lord, section 320, my lord, grievous hurt. The seventh proposition is given, my lord. Fracture or dislocation of a bone or tooth, which has happened here, madam. And eighthly, any hurt which endangers life or which causes the sufferer to be during the space of 20 days in severe bodily pain, my lord. And thereafter, you also might see 335, my lord. Voluntarily causing grievous hurt on provocation. Whoever voluntarily causes grievous hurt on grave and sudden provocation, if he neither intends nor knows himself to be likely to cause grievous hurt to any person other than the person who gave the provocation, shall be punished with imprisonment for this of a description either for a term which may extend to 4 years or with fine which may extend to 2,000 rupees or with both. I was arrested on 2/7/2016 and since then I'm in jail for the last 7 years, madam, 5 days less.
Look at your explanation under 313. What have you stated? Where is the provocation?
And provocation, I'm taking from the statements of the PW 1, 2, and 3 matter. That they have said that I have spelled out before them. That on provocation, I had given that blow to my brother.
Yes, madam.
Section 334, 335 will not come. This is in respect of another person. If he intends to hurt, so this will not come in the facts of
Correct.
the instant case. Now here, what I can see, even if we brush aside the dying declaration from PW 1 statement, because she said initially there were no one, then she met her.
Those, I think those can be explained because I think their evidence might have been in Assamese.
SMS, yes. She said that when I met him, he said Alongbar has attacked him. But at the next sentence, she said she was not in a position to speak.
In
So
the,
even if we brush aside dying declaration, there are extrajudicial confession. Sister, father, her wife also. Alongbar said there was a quarrel and I've hit. So in the face of these evidence, there is no denying the fact that he was the perpetrator. There was no one
there
else.
is no denying. You cannot escape from that.
As far as he doing the crime is not, cannot be disputed.
That's not, cannot be.
And there is no cross. There is no
There's
contradiction.
no cross at all.
No contradiction. Nothing was brought on record. So these evidence stands. These
Nothing, no
evidence.
cross to the effect that he did not commit the crime.
There was no cross to that, nothing. Now going to the medical evidence, blunt portion, blunt side, X, the blunt side perhaps was used, and that has the capacity to create that cut injury.
Correct.
That can create, that
It
can
can create, it can create.
result
Not that
in
it cannot create.
So there is nothing to disbelieve the medical evidence as well. So the quarrel part is writ large. Quarrel part is there in, even in the independent witnesses, they have said there was a quarrel.
So which one will come? 326, 304, what?
326, I have seen so many judgments of Supreme Court here. Two judgments I have where what had happened is the injuries were, the death was not due to direct result. In the cases where it is converted to 326, there what I find is death is not the direct result of the,
Okay, in
Hit.
those cases.
and person dies after some time. In those cases, cases are converted.
Okay,
And one case is also there where the assailant has hit him on the head first. Thereafter, he shot the deceased on his legs. So the Honorable Supreme Court said, if he had the intention to kill, he would not have shot him on the legs.
correct.
So in those cases, it is converted,
Okay.
and death was not instantaneous.
But out here it's on the head,
It's on the head. One injury, I think it's one injury.
one in the,
One injury. So one injury, there are judgments where it is converted to 304.
Two.
Part 2 or part 1.
part one, either one, it can, both can come.
Both can
So
come.
we'll have to see which one should be the correct.
Hmm. Which one
Part.
should be correct? 326 or 304?
No, 304, part one or part two?
Oh, yes, part 1, without any intention, but with the knowledge. Because the incident occurred in the house of the accused. Perhaps deceased used to stay in his in-laws place. Because the wife said, I was in my maternal house, he went to his father's house. So perhaps he was staying in his
No,
wife's place.
Yes, you see, it depends. Now, in the Mizo society,
Hmm.
the elder children usually, they
Ah,
leave the house. And the
yes,
youngest stays in the house.
happens. So
Then it depends upon society to society. I don't know, in Nagaland, what is it? Maybe the elders stays in the house, I don't know. But at least in the Mizo society, the eldest leaves the house,
Leave
makes
here.
it different house. Similar here.
Hmm.
I had to be kicked out of my house and make a new house. for myself.
good only leaving for the younger ones to stay.
Aha,
Or-
okay. So that happened. So maybe then he went and, visited
Aha.
his parents and his.
So the fact
family.
remains that the deceased died in the accused person's place. So it's not a case that accused came rushing to him and killed. There was some quarrel in his place. And then out of that quarrel, he had hit. So things goes in favor of the accused to certain extent. So in my humble submission, it can be converted. There was a quarrel. He himself admitted. In his 313, he did not admit this is maybe because of the advice of the lawyers or something else will happen. Don't say that. It can happen. But there are witnesses who said he made extrajudicial confession.
Yes,
So in a way, it can be converted. If not 326, 304 part 2.
326, like you said, it doesn't appear to be attracted.
Hmm.
Because the injury is caused in a very vital part of the body.
No, 326, it has to be a grievous injury. And grievous hurt is defined under 320.
No, but then that has,
Fracture
there has
is
to,
there.
but there has to be something else before that, no?
Huh.
Before 326 can be applied, what is the ingredient?
Huh.
Otherwise,
Hmm.
it would be the same as 304.
No,
They have-
it has to
326 is
come
what?
within the definition of 320.
Yes,
And
so
320 fracture is there. So fracture, in our case also, there is fracture of frontal bone. Except cases under
there was a
335,
fracture, there was a fracture.
there is a fracture of the frontal bone.
But 335, then it's 335.
No, no, fracture of. There is no fracture, it seems from the
Doctor's report.
Postmortem, original consent. In his evidence he said, but then in the postmortem report. It was there. It would. Frontal bone. This is lacerated and blood. Seen left side of the split lacerated injury. Seen left side, frontal bone. So no fracture, I don't think so. Blood clot. I don't. I have a fracture.
Where is the report page?
Fracture is left.
That is in the evidence.
In the report, Lordship will see
Report is that page,
page. Just-
postmortem 38.
So, so,
38.
38.
It is fracture. Fracture, it is somehow it continues. Reason. Split lacerated forehead left. It is an actually problem. This is ash.
Page 41, the bottom injury, muscles and bones.
Yes.
What is that hashtag?
Fracture, I've seen,
That's fracture. So that's fracture.
Lordship, I don't see F fracture here.
Come to 41, page 41. 41 of the paper
Yes.
book.
But
I don't
case
think so.
42,
This
my
is
lord,
F.
fracture, nothing,
No, come at the bottom.
bottom, my lord.
Injury,
Split
Yes.
lacerated forehead,
two.
left frontal bone.
This is
Ah.
left frontal bone. So injury is there on the left frontal bone.
Ah.
I don't think so fracture is there.
There is a
So
specific
that
column.
hashtag, that
Hashtag is fracture. I have subject to correction, I don't have. Oh, acha, acha.
In fracture, there is a.
No, this one is fracture. This one I didn't know. Hashtag, I told her it's a hashtag, but then I didn't know it's a fracture. So if it is a fracture, as of course, it's a fracture, then 326 will come. No, hashtag is fracture, no.
okay. Heard, Mr.
B Prasad.
B. Prasad, learned counsel for the. Then amicus curiae and Miss El Jahan, addition PP. You are there also, madam?
Therefore, informally, your lordship.
Okay, Miss,
Legal aid. I'm legal aid counsel.
appearing for the informant. You want to ensure that he remains behind bars throughout his life.
I'll see how long he was inside.
7 years. On 7/2/7, I was arrested.
It's written
And
in the.
within the 8 months, the entire proceeding was trial.
So you have been in jail for 7
Six
years.
7 years, 5 days less, my lord. Two
Six-
7.
6
Second
years,
of it.
3 months. It's
That is
written in
wrong.
the cause list.
That is wrong.
Oh, acha, acha. I'll check.
That is from the
Anyway,
date
so,
of judgment.
okay, yeah, hearing concluded, judgment reserved. So we'll see whether how we can,
Lordship. It's written he was inside for 6 years or so.
That is from the date of judgment.
2/7/2016. And then he
So,
was bailed out.
Rakesh,
No, no. Huh? He's dead inside since then.
Also, no?
Huh? Acha, acha. He was in jail all throughout from the date of his arrest. So 2016 till date.
what to do happens.
Yes. There was no one to take his.
No
bail,
one
so-
to blame,
Ah,
but
no.
no one to blame in.
Uh-huh,
no one
yes.
to-
এটা ওখানে
Something dropped. I hope it's not some
No, no.
important document.
This is my paper.
Okay.
Cause list. Lordship.
May it please your loss.
Tiff between the daughter-in-law and the mother.
Huh?
Tiff between the daughter-in-law and the mother.
Daughter-in-law and mother.
Son expired. He was a railway employee.
Pension,
It
what do you,
was sent for mediation.
Huh?
It was sent for mediation
Mediation.
by this honorable court, my lord.
so what has
But
happened?
mediation failed,
Failed.
failed.
Mediation,
And now-
mother-in-law did not cooperate as. per
No,
our
no, the
information.
other way around, my lord. It's the daughter-in-law who wants everything, my lord. She does not want to share anything with the mother-in-law. Now, my lord, the issue is that some family intermediaries are on the job. But if there is a good mediation, my lord, we are still willing, my lord, because the mother was dependent on the,
So you all decide what you all want to do.
my lord,
I don't
what
know.
has
I-
happened is, in the meantime, my lord, what we do, the mother-in-law, she disputes the marriage, my lord. There is already a declaratory suit filed. So, my lord, we'll have this, my lord, say sometime in the first week of August after the vacations. In the meantime, my lord, if they can also cooperate, we also cooperate. Something happens, because if the declaratory suit now, something may work
No,
out.
no, you see, you're fighting over what?
The pensionary benefits,
Oh, pension, one is pension.
pension benefit. Gratuity has already been given
Pension
to,
will have to go to the wife.
no, my lord, if the mother
As
is
per the
also a
interim
dependent.
order of this honorable court,
No, no,
she is
if the
getting-
mother is also a dependent, my lord, on the employee, then, my lord, she is also required. There are, my lord, provisions for that.
Where, under what rule?
And our allegation is, my lord, she is already married. That, my lord, we could not establish. Now, my lord, in the declaratory
That's a
suit,
different issue.
those are the issues, my lord, which are
Okay,
there.
okay.
And she is also
Because,
claiming
okay, so anyway, we cannot have a hearing today.
no, my lord, it would take some time, my lord. If lordship can have it, say sometime in the first or second week, my lord, maybe.
Depends, you all are the ones representing your clients.
Subject to what my senior my friend says. August.
Okay, and the mediation failure report has not come. Huh? It has come. It's an
My lord,
office note.
otherwise also, my lord, may I make a
Annexure? N.
It was referred by order dated 2/8/22 to my lord.
Okay, so since mediation was not successful, now what do you all want? You all want to have a,
My lord, subject to correction, my lord. May there be an attempt made before this honorable court while in the registry, so there is a mediation center also.
Yeah.
Because
I'm
my lord,
open to it.
before, as per the report, before Debrugurh court. it
Because there was
referred.
undue influences on the, on that, my lord. We had tried
For the
to
hands of
inform the
justice,
court
my
also. She wants to compromise,
who wants to compromise?
the daughter-in-law.
Daughter-in-law.
But my lord, she is not being forced to. I'll not go that any further. She was not, this is not my statement being made here. I made this
So
statement before the
it'll be done in the absence of the lawyers.
lawyers. Let it be done in the absence of the lawyers. That, my lord, got it.
Agreeable?
Agreeable.
No, no, not that so much.
Huh?
She is all along cooperating as. it
No,
is
no,
a-
no, no, I am asking you a question. In the absence of the lawyers, the mediation will be done.
In the Guwahati High Court, if the parties come before, both the parties come, my
Without
lord.
advocates, only parties.
Only the parties will go, not the lawyers.
Yes, yes, my lord, yes. Well, let,
Fine.
both the parties should be there. sir.
Yes, without their lawyer, they should not go at all.
Gotcha.
Okay, right. Third, Mr. M.H. Raj Bharat Bhuyan, Learned Counsel for the petitioners in WPC number 3091/2021 and WPC number 1886/2020. Mr. U.K. Nair
For respondent
Appears-
five,
for the respondent number 5,
mother, madam.
the mother. First up.
In two,
The
309.
matter pertains to the pensionary benefits in respect of the son who has since died.
Firuz Ahmed, husband of the Rihanna petitioner.
Okay, in respect of Mr. What is his name?
Firoz Ali Ahmed.
Firoz Ali Ahmed, full stop. No son or no daughter, no
Daughter.
wife, or husband, anything. Full stop. That's good. Next, this matter had been sent to the this Dibrugarh District Mediation Center
I hope I remember.
for settlement. Full stop. However, the mediator, Dibrugarh District Mediation Center has submitted a letter dated 4/3/2023 to the effect that stating that the parties could not reach a settlement / agreement. Full stop. Today, when the matter is before us, the learned counsels for the parties, Mr. M.H. Raj Barbhuya and Mr. U.K. Nair submit that they would like another shot at having a settlement before the Guwahati High Court Mediation Center
Center,
in the absence of any lawyer.
lawyers.
Full stop.
Of
According
the respective parties.
naturally, we cannot have a third party. Accordingly, registry to send this matter to the Guwahati High Court Mediation Center to enable the parties to attempt a compromise / settlement
They'll take. the-
of the issues. They will fix the date. I
No,
think.
not, they'll take. Mediator will fix it. He'll issue.
I have a small play in this matter, I am also appearing, my lord. Lord, after I am appearing for the Kazi, my lord, so he need not appear before the mediator.
No,
my
no.
lord. Yes, ma'am.
Okay,
That may be
Mr.
clarified, yes, my
Mr.
lord. Parties may appear, my lord.
Okay, so you're appearing for the Qazi.
Yes, my lord.
What is the Qazi got to do? with it?
One
Because
nothing
one of
to
the
do.
marriage was
Marriage-
disputed, that's
marriage-
why.
my lord.
No, we just say, parties. When we say parties, that is only the mother
And
and the daughter-in-law.
Mine. I'm the.
Obliged.
It means it.
Go to the mediation center again.
On this matrimonial appeal,
When can you come?
31st of August, my lord, if inconvenient, my lord.
Okay, right. On the prayer for adjournment made on behalf of
KK Parasar,
AK,
Parasar,
KK,
KK Parasar.
KK Parasara, CDC, whose wife is reportedly in hospital. And which is not objected to by Mr. P. Baru, Mr.
Tapas Das, T Das.
T. Das, the counsel for the petitioners. List the matter on 31/8
As a number one, if possible.
as item number 1
Deeply obliged, my lord.
in the admission column.
Deeply obliged.
Wait, please, your lordship. Lordship, I would to mention for adjournment item number 5, lordship.
5,
Item number 5, lordship, where the review petition has been filed by the state lordship.
Huh?
A review petition has been filed by the state
Correct.
lordship here. Now, this person, this was filed in 2018.
correct?
Subsequently, there has been some development also, lordship.
Huh?
Some of the irregular illegal teachers have been in terms of the cabinet decision in 2020. some of them has been also accommodated.
Accommodated.
Lordship, but we have to verify whether these petitioners are among them or not. And also we have to reconstruct the file, Lordship. So Lordship, and
Not only that, you have to take steps also.
Lordship, we have to
Then?
take step from respond number 1 and 2, Lordship also.
Then,
Lordship, allow us to take step on respond number 1 and 2. And Lordship, fix the matter after vacation, Lordship. In the meantime, we will obtain instruction as to whether this, the fate of these petitioners also, Lordship, whether they have been accommodated or not. Possibly we have cabinet decision, Lordship.
Mister, what is your name?
P N Sharma,
Mister
P N Sharma,
N Sharma,
PN,
P N Sharma,
Lordship.
Learned Counsel for the State Review Petitioners. State slash review petitioners, submits that the matter may be adjourned to enable him to reconstruct the file and to obtain instructions as to whether the writ petitioners have been accommodated.
Lordship,
Huh?
pursuant to the Lordship.
As to whether the writ petitioners have been accommodated or can be accommodated.
Lordship, in terms of the cabinet decision.
In terms of the
No,
cabinet decision,
It cannot be now, whether it has been accommodated, they have been accommodated. or not. In terms of the
whether,
cabinet
no, acha, whether, don't say can be, this say, whether they have been accommodated in terms of the cabinet decision
2020.
made in the year 2020. Full
Right.
stop. He also submits that he will take steps for service of notice upon the respondents number 1 and 2 within.
Within Lordship,
Look, Mr. Counsel,
Yes.
since 2018,
Lordship.
you have not taken.
within.
Why shouldn't I dismiss your case? I'm
Lordship,
thinking,
Within 3 days, Lordship, within 3 days.
within 3 days.
Lordship. Lordship,
Keeping in view the fact that, no, full stop, keeping in view the fact that no steps have been taken by the state even after 4 years. 5 years or 4 years, I don't know,
It is of 2018, Lordship.
for 5 years, cover. The matter, the matter may be dismissed if no steps is taken on the next date.
Lordship. Lordship, may I prefer taking steps within 5 days, Lordship, because we have to reconstruct the file also, Lordship, 5 days.
3 days. You have taken, you have already got 5 years, another 3 days only.
Lordship.
Please, your lordship. With the consent of the other side, I'd like to mention item number
Huh?
20.
Actually, list the matter after the vacation.
Lordship, a date may be fixed, your lordship. on
Which one item?
Item number 2 and 3, your lordship. Can it be on 25th, your lordship, if it is not inconvenient?
His senior is out of,
Huh?
his senior is out of his.
Where is the senior?
Lordship, he is in Itanagar for a matter.
Huh?
He is in Itanagar, your lordship.
Itanagar. What is the matter about?
They have challenged the feasibility report based on which petrol pump was constituted.
Sorry. Setting.
On the prayer made on behalf of Mr. S. Das, D. Das, Senior Counsel for the petitioners, which is not objected to by the other side. The matter is adjourned till,
25th.
Huh?
25th.
why so short?
July, madam, is a part of.
And if you-
25 July.
if you have like- May I please, your lordship? Lordship, I beg to mention item number 9, lordship. Lordship, today only I'm.
Item
Item 9.
9, yes, what about item 9?
Lordship, it was a bank loan matter. Today only I'm instructed by my client that matter has been settled amicably.
Matter has been settled.
Yes, yes,
So you want to withdraw this IA?
yes, lordship. Or I can bring it on record also if the matter is.
No, if we will accept your submission.
Lordship.
Miss
M. Bora.
M. Bora, appearing for the applicant, submits that she would like to withdraw the application as the grievance of the applicant has been settled. Full stop. In view of the prayer made by Ms. M. Bora, the application is dismissed as withdrawn.
Obliged, lordship.
May it please your lordship, I am appearing on behalf of the standing counsel, this honorable High Court, my lord, appearing for response numbers 2, 3, and 4.
No, we have received our instructions, when I pray for 3 weeks time for filing affidavit in opposition. This
Mr.
goes for vetting also.
Mr.
I'm U Pathak, my lord.
Huh?
I'm U Pathak appearing for
Mr. U
HK Das.
Pathak appearing on behalf of Mr.
HK Das standing out.
H K Das. Standing counsel for the respondent number 2 to 4
Yes, my lord.
submits that instructions have been received and
3 weeks time.
they will be filing their affidavit in opposition within 3 weeks. This is the matter after 3 weeks.
I'm obliged, my lord. Deeply obliged, lord. Yeah, please, lord.
Mr. A.R. Shankar will take the item number 6, my lord. For the time being, pass out. Item number 6.
Okay, next item.
May I proceed, yes, my lord? My lord,
So
this
there is a
IA for.
change of name,
Yes, my lord.
change of name.
Yes, my lord.
Name has been wrongly mentioned, wrongly typed. Is it?
Wrongly,
Is your fault.
no, my
is it?
lord, it is fault of registry, my lord. They
Registry.
have recorded it the wrong name, my lord.
In the writ petition, the name was recorded correct.
Yes, my lord. My lord, kindly, one line, my lord. Kindly page 10, my lord. Page 10.
Let us see the writ petition.
Page 10 is first son of late Mustakin. We are typed as a Mustasin, not Mustaqin.
So it is your mistake, not the registry's mistake.
No, my lord, it is recorded by the registry in their page.
Huh?
In their page, let Mustaqin here recorded. We are typed as a Mustasin.
Okay, it should be, let us see the impugned order.
Now, my lord, my prayer is, my lord. Kindly page 8, my lord, in prayer page. Let Musta
Okay, it should be Mustasin.
Mustasin
So the registry has made a mistake.
yes, my lord. Let Mutasin.
So you want the correction in the cause title and in the order dated cause. In the order, where is the order?
29(3).
Okay, right. Heard, Mr.
N. Ahmed.
N. Ahmed, learned counsel for the applicant who submits that correction / modification in the cause title of the order dated 29/3/2023 passed in WPC number 1761/2023
Yes.
should be made in view of the fact that the name of the father of the petitioners, correct? Father of the writ petitioners has been shown as
Mutasin Ali.
Mustasin.
Mustasin.
Has been shown as late Mustakin Mustaqin Ali Barbuya. That is at page 10. You see the names. Even though the writ petitioners in the writ petition had clearly mentioned the name of the father of the writ petitioners as
Mustasin.
Mustasin. S.
Elias
Mustasin.
Mutasin.
Ali Barbuya.
Mutasin Ali Barbuya.
Ali Barbuya. Okay. He accordingly submits that the name Mustaqin should be replaced with the word Mustasin.
Yeah.
Mustaq. That's correct.
Yeah.
Mr. What is it?
C Sharma Lordship.
C. Sharma appearing for the
Response number 1 to 4.
respondent number 1 to 4. Submits that he has got no objection.
Lordship, but Mutasin is nowhere mentioned in the writ petition.
It is mentioned.
Mutasin Lordship.
Huh?
Mustasin Ali Borbuya alias.
Correct. That's what he wants. He wants his huh?
Mutasin is not mentioned, Lordship. The second name alias Mutasin, that is not mentioned.
Have you got the writ petition with you?
Yes, Lordship.
Please look at the in the matter of. See writ petition number 1, son of, what does it say?
Lordship, page number 3.
Page number 3, look at it. Son of
Son of alias Mutasin Ali Borbuya.
Mustasin. So in the order that has been passed by this court, instead of Mustasin, it has been written Mustaqin
Yes, Lordship. Lordship, but if Lordship takes the prayer portion of the IA.
of the IA.
Yes, Lordship. By this honorable court, by modifying, rectifying it as late Mutasin Ali Borbuya, alias late Mutasin. That name is not,
No, okay.
that name is not mentioned in the.
We do not know who is Mutasin alias. How can it be alias Mutasin?
Yes, Lordship.
The same name.
How does it make a difference? They will check from the record.
Yeah, okay. Into different documents, into two different name alert there. Therefore.
Okay. What do I said?
Mr. C. Sharma, counsel for the respondent 1 to 4, submit that he has got no objection.
No, prior to that.
He accordingly submits that,
You give up this prayer with regard to Mutasin. Why do you need it?
Yes, madam.
You give up the prayer regarding Mutasin. That is not part of your thing. You'll have to change, then you'll have to change the entire writ petition pleadings. Because in the CIS, it will not show like this. You have to file an application for amendment of the writ petition.
Then only my lord, Mustasin.
Mustasin, because the problem is, it's not like before.
Yeah.
Now everything is put in the CIS.
Yeah.
If you change the name, and if that name is not there in the original CIS, then it'll cause problems. So you have to make amendment, allowed, there has to be amended petition will have to be filed, everything. Okay, Mustasin, it's done. Next para. On perusing the writ petition, it is seen that the father of the writ petitioners was recorded as Mustasin Ali Barbuya. Full stop. However, in the order dated 29/3/2023 passed in WPC 1761/2023, the names the father of the petitioners is shown as Mustaqin Ali Barbuya. Full stop. As the same shows as this above shows that there has been a genuine mistake committed by the registry, the prayer of the applicant for modifying for changing the name of the father of the petitioners to late Mustasin Ali Barbuya from Mustaki Ali Barbuya is allowed. Accordingly, registry is directed to make necessary correction to the order dated 29/3/2023 passed in WPC 1761/2023. The IA accordingly allowed and disposed of.
Obliged, my lord.
This can be thrown. This can be thrown.
Lordship, may kindly have a look at the terrible condition. But Lordship has passed some strict order on the earlier occasion. 9.
You call them,
My lord.
you call someone. Tell your juniors to call, some lawyer. Appearing for the social welfare department.
Procedure for the point. My lord.
Call Mr. N. Goswami if
Yes,
there.
my lord. N. Goswami. N. Goswami. N. Goswami. But, today maybe some problem. Most of the lawyers are leaving the court.
Why?
My lord. My lord,
Because after lunch, because it's after lunch. Or
after
is it,
lunch,
Huh?
after lunch, my lord.
it happens. Is it? But I didn't notice that when I was looking, while I was heading bench for, I didn't have such problem. In fact, the court was crowded
Yes,
till evening,
yes, my lord.
till rising. So is there something going on?
My lord, in the, up to 1 PM, there was a advocates, my lord, demonstration, my lord, dharna.
Oh.
Sit on demonstration.
Where?
My lord, in our old, in before old building, my lord.
From the Guwahati, High Court bus?
Regarding shifting
Huh?
of the high court. my lord.
Huh?
Regarding shifting of the high court location.
Okay. There was a dharna by the lawyers.
Yes, my lord, right, my lord.
Okay, did you participate?
I also participate, my lord.
Then they have not come to the court after that.
They are supposed to come, the program is only up to 1 PM.
Okay,
Second half, they should attend.
maybe they are still in the mood to just sit around that side.
My lord.
So what is to be done?
My lord, should list after vacation, my lord.
Right. Mr. A.R. Sigdar appears for the petitioner. What's up? No one appears for the respondents. What's up? In the last order dated 9/5/23, the state respondents were to obtain instructions. No, the state councils was supposed to obtain instructions with regard to whether the post of Anganwadi worker had been filled up in terms of the advertisement dated 8/2/2019. However, in view of the absence of the councils for the state respondents, matter is adjourned for 2 weeks. List the matter. After 2 weeks, the state respondents council shall obtain instructions
My lord, state council,
with
my lord,
regard to the above.
my lord, his name, my lord, Goswami's name may be shown in the call.
We do not know. No one is there. By the next date.